Most people don't like to talk about their mortality, and as a result, most people ignore their estate planning needs. But this is a very important subject, and if you're over the age of 18, you really need to start on your estate plan. Put simply, an estate plan is your instructions as to what happens with your assets if you were to pass away or become unable to make decisions for yourself. To have a comprehensive estate plan in place, you need to consider a number of different elements, and this can be a very complex area of advice, particularly if your situation is a little complicated. Today, we are looking at one aspect of estate planning, and that is the will. So first of all, let's consider what a will is. Now, most people know what a will is. It's a way to ensure that your assets are distributed to your preferred person or people in the event you were to pass away. Wills cover things like who receives your assets, who will care for minor children, funeral plans, donations to charity, and the establishment of trusts. When drafting a will, there'll be a few technical terms which come up, and you need to have an understanding of what these terms mean. So let's cover off some of them now. The beneficiary. This is the person who will be receiving an inheritance. The estate, that's the assets you own at the time of death. The executor is the person or people named responsible for winding up the affairs of the deceased person. The guardian is the person or people named to care for minor children. Probate is the document by which the court recognises the authority of an executor to act under a will. The spouse can be a husband or wife, a person in a civil relationship, or even a de facto partner. And the testator is the person who makes a will. When it comes to drafting your will, there are essentially two ways that you can do it. The most cost-effective way is to draft it yourself. You can get a DIY will kit for less than $50, and it comes with a template and instructions to write up your own document. Before going down the DIY path, you should be willing, no pun intended, to put the time and effort into preparing your will properly. You should read and follow the instructions that come with the will. If you don't execute your will properly, there's a good chance that it'll be deemed invalid. If your situation is a little more complex, or you simply just don't trust yourself to write the will, then you can get professional help. There are many estate planning companies which draft wills for you. Some even allow you to do the will online. There is also a public trustee in every state, which is a government-run estate planning agency who typically offer reasonable rates. When drafting your will, you can make it as detailed as you like, but this is often not the best idea. Where possible, we always suggest you try to keep it as simple as possible. The more complex your will is, the more costly it can be to draft, and the higher the chance the will will be deemed invalid. Given this, a simple will is the best approach for most people. However, there are certain circumstances where a more complex will is appropriate, and this is often due to additional complexity in your financial situation. Examples of a more complex situation might include having been through a divorce, have children with different partners, operate a business, and hold assets in trusts or companies. These are non-estate assets. If you fall under one of these categories, then I would strongly suggest you seek advice from an estate planning specialist. Once you have a valid will, you need to store the original safely. This can be at home, preferably in a safe or locked cabinet, or you can also pay to have it stored by your attorney. If you store your will in a safe or locked place, make sure someone trustworthy can access it should something happen to you. While wills don't have an expiration date, it is important that you review your will regularly. You should look to review your will at major life events to ensure it remains relevant. Some examples of when a will should be reviewed include marriage, the birth of a new family member, significant changes to assets, divorce or separation, death of a beneficiary, moving to a new state or territory, or if a named person is unable or unwilling to act. If you do create a new will, this will supersede your old will, and the new will normally state something along the lines of, I hereby revoke all previous wills and codicils. If you fail to write a will and you pass away, you are said to die intestate. Under this scenario, your will be distributed in accordance with the rules of intestacy. Each state and territory has their own set of intestacy rules. You should not rely on the rules of intestacy to distribute your estate, as the assets might not go to your preferred beneficiary, and the costs involved with intestacy can be significant. The final thing to consider is your non-estate assets. We mentioned earlier that assets held in a company or a trust are considered non-estate assets, meaning they are not dealt with by the will. In addition to this, there are other assets that also sit outside the estate. If property is owned jointly with another person, then it does not form part of your will. Ownership will automatically be transferred to the surviving owner upon death. If you have a valid beneficiary nomination on your super fund or life insurance, then chances are this will also not form part of your will, as your death benefit will bypass the will and be paid directly to the named beneficiary. If you think establishing a will is an appropriate strategy for you, we strongly recommend you speak with your financial advisor and an estate planning specialist. They can help assess the appropriateness for your particular situation. Please note the information contained in this video is general in nature only and does not take into consideration your objectives, financial situation, or needs. As legislation is constantly changing, the accuracy of this information is only current as at the time of recording. Before relying on the information, you should check to see if there have been any changes.